Welcome to a conversation about the Bill of Rights. And today, the Free Speech Center and our guest author will be exploring what these rights say and how they apply in America today. We are celebrating the release of a brand new book by our friend David Hudson. David is a professor at Belmont University College of Law. He is also an accomplished author and authority on the First Amendment and the entire U.S. Constitution. This is the Bill of Rights, a free book available to each and everyone who requests a copy, written by David. It is a nonpartisan, thoughtful, reflective, and very accessible new book. David, welcome and congratulations on your new book.
Thank you, Ken. It's an honor to be here.
I have to ask, David, now that we have put it back in print and you have updated it, and it reflects the law of another decade and a half, how do you see this benefiting that next generation? Why do young people who are in grades, let's say 7 through 12, need to understand these rights?
Well, in order to be full participants in our constitutional democracy, people need to understand and appreciate these individual freedoms. And I think to be fully functioning members of society, if you don't know and appreciate your rights, you can't protect them and you can't fight for other people to have those rights. And I think that too often, sometimes there was a focus on standardized testing and scores in math and science. And I think civic education got a short shrift. And that's why I'm eternally grateful to you for providing me the opportunity to revive this book, because it was laying fallow there for a few years. And I really appreciate what the Free Speech Center is doing and what they've done to make this publicly accessible.
Well, it's kind of you, David. We're always eager to find ways to explain these principles in the very basic way that you do. As a professor myself at Middle Tennessee State University, I will say I've been surprised. I've been surprised even when I taught as an adjunct at Vanderbilt, how few students actually have a grasp on the Bill of Rights. That it may well be that today we have nothing but constitutional scholars in the Zoom audience. If that's the case, you probably don't need to watch if you've got this figured out. But for most Americans across this country, they have an understanding in general of the First Amendment and probably the Second Amendment. And then it sort of falls off right from there. And there are at least probably 3 amendments that, unless you're competing on Jeopardy, it's not likely you know much about. And what we're going to do today is actually march through the amendments so that at the end of this conversation, you will have a good grasp on the Bill of Rights and the 14th Amendment, which expands those to the states and each and every one of us. And it's actually kind of a fascinating story, how these core rights stack up together and what they collectively protect. Now, I want to say this at the outset. We want these books in the hands of teachers and students and anyone, any American citizen or otherwise, who has an interest in our Bill of Rights. We want to make that available to you free of charge. And it comes in one of 2 ways. If you are an educator, if you are a teacher, if you are a professor, we want to provide this book to you in paperback form. And if you send that to our email address, we will make sure a copy of that is sent to you. We also, if you are interested in a digital copy or a digital copy that is easily read on your Kindle, we'll make that available as well. Just send us a request to Free Speech Center at mtsu.edu. Free Speech Center at mtsu.edu. And if you're not asking for a paperback copy, we'll simply send a digital PDF to you and you'll have a copy. It may be that a teacher will get 1 copy of the book and then as many digital downloads as you need for your class. So we want these out there. We want David's fine work to be shared. So please take advantage of that. So David, we don't want to play favorites. You and I worked in First Amendment law for a very long time, but First Amendment happens to come first in the Bill of Rights. So let's talk about the Bill of Rights. If you haven't looked at it lately, there's sheer poetry there. Congress shall make no law respecting the establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. 45 words, unchanged, but not unchallenged. since 1791, the year of ratification. David, does it ever occur to you that they packed a lot in that single amendment? That could have been 5 amendments.
It certainly could have. If we look at certain state constitutions, sometimes freedom of religion is a separate freedom, and then freedom of speech and press is a separate amendment, and then assembly and petition is grouped together. So I have a preference. So obviously, working all those years with you at the First Amendment Center, I like all 5 freedoms based together, but they really are our blueprint for personal liberty. They're what Justice Benjamin Cardozo famously referred to the First Amendment as the matrix, the indispensable freedom. If we didn't have it, then we wouldn't have really anything.
And they do philosophically fit together because they collectively give us freedom of conscience and who we are as individuals. So we're, thanks to the First Amendment, we can say whatever we wish. We can write whatever we wish. If we're not happy with things, we can petition for better things to happen. We can assemble and exchange our views about society. And of course, we can draw strength from the God of our choice. Collectively, they allow us really to think as we wish and to be who we are. And I'm not sure even though they drafted it, I'm not sure James Madison and others who had input appreciated the scope of what they were actually accomplishing.
I think that's right. And, in a lot of countries in the world, unfortunately, people don't have the right to criticize the government. And that's really the essence of what the U.S. Supreme Court did in New York Times Company versus Sullivan, where the court talked about the profound national commitment that debate on public issues should be robust, uninhibited, and wide open, and can include sharp, vehement, and sometimes unpleasantly caustic attacks upon public officials. And that's what it means. I view the First Amendment as really the essence of freedom.
I agree. And I think if we're fair, probably religion was first and foremost to that first generation. That was a dominant concern of all the early settlers in what would become the United States. And so religion is no surprise. And the others are all vehicles for actually keeping government in check in one form or another. I have sometimes said in probably when I've been in a jingoistic mood, but I would talk about America being the most free. And I point to the First Amendment as an example. America, more than any other country, has the most robust set of freedoms. A big part of that is what you said, the New York Times. You can make a mistake. If you're covering a prominent American or public official, as a journalist, you can make a mistake as long as you're not acting with malice or recklessness. That's a very powerful protection that very few countries can match. I'm not sure any of them can. And then you just look across the board, tolerance for religious faiths, incredibly strong here.
Yeah, and there's a lot of countries that'll say they protect that. So there are other written constitutions in the world that pay obedience to free speech, but they don't really practice it. And I think that's why it's so important, the efforts that you're doing at the Free Speech Center, because it's our values. It's our values as Americans, in addition to this wondrous text that makes America so great. And that's why we need civic education. We need, I think, books like this in the hands of as many people as possible.
So let's look at those 45 words very briefly. They are all written about the medium, really, of 1791. We had books and we had newspapers, but that was it in terms of hard copy. So I am curious, why do you think it has been so easy to take those media rights and extend them to unimaginable means of communication? It didn't take long for the Supreme Court to recognize that the internet had to be protected under the First Amendment.
That's right. And the phenomenon truly in American history is when there was a new medium of communication, initially there'd be a wave of censorship, and then ultimately there would be protection. So, for example, with movies, I believe back in 1915, the U.S. Supreme Court said no protection, but then in 1952, and Joseph Burstein v. Wilson, the court said no, medium is a form of free expression that's protected by the First Amendment. In June of 1997, in a case called Reno versus ACLU, the U.S. Supreme Court held that there's no basis for qualifying the level of scrutiny. They essentially gave what the late great attorney Bruce Ennis said they gave a legal birth certificate to the internet. And that's the beauty of the Constitution and the Bill of Rights, is that the language is written in general enough terms that allows for flexibility. And it was written not just for the founding generation, it was written for future generations as well.
It's interesting that you talk about the general terms. Sometimes those general terms help us. 45 words of the First Amendment make clear the broad scope of liberty in terms of communicating with us. Let's turn now to arguably the most controversial of the Bill of Rights, and that is the Second Amendment, the right to bear arms. This language is subject to so many interpretations, and that, of course, is at the heart of much of the debate. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. To analyze this, you have to ask, what is a militia? Was that a conditional element of this? And what are arms, in fact? For that matter, what would constitute infringement? A lot of people of good faith and scholarly backgrounds can debate what this amendment says. As somebody who has to share with the next generation what it says, what's your message about the Second Amendment?
Well, what's fascinating about this is that initial edition of this book in 2002, the Supreme Court had never ruled that the Second Amendment protected an individual right. That did not occur until 2008. And then it wasn't until 2010 that the U.S. Supreme Court incorporated that right. So the thing to really appreciate is that Second Amendment law is being made right now. And you're right, it's a very oddly worded provision. In both decisions, District of Columbia v. Heller and McDonald versus City of Chicago, or City of Chicago v. McDonald, both of those decisions were 5-4. And what Justice Antonin, the late great Justice Antonin Scalia, who wrote the court's majority opinion in Heller, is he said the militia clause was the preamble, essentially, and that the right to keep and bear arms shall not be infringed. That is the so-called operative clause. And so according to Justice Scalia, the right to keep and bear arms was the focal point, and that certainly protected an individual right. One way to think about it is, do we view the right to militia as a collective right, the more collective right of the militia, or do we view it as an individual right? And at least since 2008, from United States Supreme Court rulings, the individual rights model has triumphed. And it's really a very interesting development. And of course, now a lot of the litigation devolves into whether certain forms of gun regulation comport with the Second Amendment. And there are a few Second Amendment cases, I believe, coming up on the Supreme Court's docket. And what's fascinating is that when the court is exploring and trying to understand Second Amendment jurisprudence, they're drawing parallels to the First Amendment, right? So just as the First Amendment does not protect all forms of speech, right? We don't have a First Amendment right to perjure ourselves in court or extort money from someone. That's been used to reason that the Second Amendment is not unqualified and doesn't give everyone the right to have a gun wherever they want and any type of weapon they want. So it's just a fascinating phenomenon, and one that, hopefully there'll be a third edition of this book at some point, and we'll be able to add a lot more based on the development of Second Amendment jurisprudence.
And you make a greater point about not only the enduring nature of the Constitution and its Bill of Rights, but also the relative malleability of it. You talk about the Second Amendment law has largely been written this century, and really press law was largely written in the 1960s and 70s in this country. So no matter how ingrained in stone we may think it is, it turns out that changing society and now changing justices as well can alter that. Just on a personal note, I've struggled with the Second Amendment, and I understand that this was intended not just to guarantee hunting, it was guaranteeing some level of security, security of the state against enemies of the state, or the state against the national federal government. And if you believe that's the case, then what does arms look like? Because the only way to keep an aggressive federal government from squashing your state would be to have the same weapons they have. And does that mean nuclear weapons are protected under the Second Amendment? Obviously, you could do a week worth of conversations, and in the end, it's going to be 9 people in Washington, D.C. who decide what the Second Amendment says.
No, I do think, for example, Justice Scalia and Justice Stevens read the historical record differently. From all of our reading, I do tend to favor that it was supposed to protect both a collective right and an individual right. It was a freedom in the English Bill of Rights of 1689. Joseph Story in his famous commentaries mentioned that it was a palladium of liberty. I do think it was an individual right. That does not mean that there cannot be reasonable state regulation of firearms.
Which brings us back to the definition of arms. And at one point, does something not become an arm as anticipated by the founders? Okay, you've done some heavy lifting now, First and Second Amendments. Let's just take a break and go to the Third Amendment, which guarantees that no soldiers can be placed in your home by the military in a time of peace. Obviously, not cited often by the U.S. Supreme Court. What is this amendment all about?
This one really is purely historical and prohibited the government from storing troops in private citizens' homes. So there's a federal appeals court case, I may mention in the book, there's a federal appeals court case from 1982 where during an emergency, I think there was a housing of some troop, but it's just something that never really comes up. It comes up as an amplifier of the right to privacy, that the reason why it amplifies the right to privacy, right, is the government can invade our home and stop and store troops there.
And it literally, when you look at it, and we're about to turn to the fourth, when you look at those two together, they are about keeping government out of our homes and out of our businesses. So let's move to that Fourth Amendment, which also looms large in case law of this century and of the 20th century. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrant shall issue but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. So that gives us a guarantee that the government can't come in and take our stuff, search our stuff, without following a process. It doesn't entirely protect us from being, obviously, having a search of our home by the government, but we are holding them to a standard. Process or substance here, David?
It's both. And so the amendment doesn't say that the government, as you said, can never search us. It says they may not engage in unreasonable searches and seizures. And so that has required a lot of interpretation in case law through the years by the court. One of the ways that the Supreme Court has examined this is through something called the reasonable expectation of privacy test. If an individual does have a reasonable expectation of privacy, then the burden on the government increases. And privacy is at its zenith or high point in the home. And warrantless searches of homes are presumptively unconstitutional. So if we look at the text of the Fourth Amendment, one of the ways that a search can be reasonable is if it's backed up by a warrant that has probable cause within the four corners of the warrant. In other words, if you read the warrant, there is a fair probability that contraband will be found. Probable cause is one of those great terms of art that the court has defined differently over time. But that's a protection. One of the things about the Fourth Amendment, right, is it was designed to protect us from writs of assistance and so-called general warrants. which were practices in which, for example, the British could just go on our ships and just search anything. And general warrants were roving fishing expedition type warrants where you could just search all the way through a house. And so that's why that last clause in the Fourth Amendment is very important, the so-called particularity requirement. The warrant is supposed to particularly describe the place to be searched and the things to be looked for. And the Fourth Amendment is really, really important. Whenever I go to speak to young people, it's really the First and the Fourth that seem to be the two amendments that concern them. And part of that may be that their Fourth Amendment rights are limited quite a bit in the public school context. But as we describe in the book, in 2009, the U.S. Supreme Court held that strip searches of a public school student, at least this strip search of a Arizona teenager named Savannah Redding, that was unconstitutional because the strip search was unduly intrusive and infringed upon her Fourth Amendment rights.
David, of course, the other reason the Fourth Amendment is so looms large is it is at the heart of abortion law as well.
That's a very interesting area. So some have qualified that more in the 14th Amendment, the Due Process Clause. Others have qualified it in the 9th Amendment. That's another area like the Second Amendment where the Supreme Court's jurisprudence with regard to abortion is one of those very contentious areas. And there's a really interesting, that's something that's going to come up a lot on the court's docket, particularly when states pass laws that are more restrictive and place more obstacles on obtaining abortions.
And the Fourth Amendment also loomed large the discussion of contraception. When states would ban contraception, you come back to wait a second, they have no, the government has no right in the home. And so abortion is tied into privacy as well. So matters of sex, aside from media-driven sex, very often come up, and the Fourth Amendment plays a role.
Yeah, and there's another role part of the Fourth Amendment. What is an unconstitutional seizure of a person, right? So it's no unreasonable searches and seizures. I think one of the issues that has arisen in recent years is the practice of stop and frisk. That's a powerful, powerful tool that law enforcement have. The U.S. Supreme Court approved that practice by an 8-1 vote in Terry v. Ohio back in 1968. But there have been some stop and frisk practices that have been declared unconstitutional because they devolve into racial profiling. But I think that the Fourth Amendment is one of the most important freedoms that we have in our Bill of Rights, absolutely.
So the next two amendments to the Constitution, and incidentally, I'm sure most of you know, the 10 amendments to the U.S. Constitution collectively are known as the Bill of Rights, the first 10 amendments. And the fifth and sixth are going to be familiar to anyone who watches crime dramas on TV or in movies. You see both of those amendments show up. And here is the Fifth Amendment. How familiar a phrase, think about it, is I'm going to take the fifth. And the fifth is about protecting people from self-incrimination and setting the stage for the amendments are to follow that guarantee a fair trial. The Fifth Amendment has been critically important, and not just in terms of the accused, but in terms of civil liberties and making sure that actually the police departments are doing a good job. What's your take on the Fifth?
Well, the Fifth is our largest amendment in terms of word count, and it contains several different freedoms. The right to a grand jury, which has not been incorporated. That's about the only right that's not been incorporated. But the grand jury is supposed to be a barrier between the citizens and the government. But you've also alluded that there's a freedom from double jeopardy, right? So if the state charges Ken Paulson with a crime and it goes to a jury trial and the jury acquits Ken Paulson, the government can't come back and try you again for that exact same crime. That's a very important protection to be free from double jeopardy. You mentioned the privilege against self-incrimination. When we look at crime dramas, like you said, the Miranda versus Arizona Supreme Court's 1966 decision, that's one of the most important decisions, sort of one of the one that's most widely known in popular parlance, right? Is that they're supposed to read you your Miranda rights when you're in custody. The Fifth Amendment also has the due process clause in it. And then the very last freedom in the Fifth Amendment is the right to just compensation. The government does have the power of eminent domain. This was extremely controversial, the case Kelo versus City of New London, when a town in Connecticut essentially took Suzanne Kelo's property. But the Fifth Amendment has, it's majority criminal, and then you have that just compensation clause at the end, and also the due process clause. It's just covers a lot of ground. We could spend the whole time on the Fifth Amendment.
I want to mention those who may have been puzzled by reference to incorporation. Incorporation is when an element of the Bill of Rights becomes applicable to the states, and that has occurred over a period from 1925 to current times. It takes an affirmative step for the Supreme Court to incorporate it into and make it apply to the state, and that involves the 14th Amendment, which we'll touch on in just a moment. So the march of crime fighting and law enforcement continues with the next amendment to the U.S. Constitution. We're beginning to see the judicial process kick in here, and this is about getting an impartial jury and making sure that you understand completely what the accusations are against you, and you have a right to say who's accusing me of this and to know who they are, and also to bring witnesses into a trial. This is about setting the playing field in level matter to make sure those who are accused are not unfairly convicted. Pretty important amendment.
Absolutely. Oftentimes the collection of freedoms found in the Sixth Amendment, and there's actually more freedoms in the Sixth Amendment than any other amendment. Collectively, they're often referred to as protecting the fair trial rights of somebody charged with a crime. That last freedom in the Sixth Amendment is the right to the assistance of counsel. And that's an incredibly important right, because the criminal justice process is so complicated and intimidating. And one of the cases that we cover in the book is the U.S. Supreme Court's celebrated decision in 1963, Gideon versus Wainwright. One of my favorite books is Anthony Lewis's book, Gideon's Trumpet. And in that case, the court essentially held, look, that attorneys in criminal cases are necessities, not luxuries, and that people charged with felonies are entitled to an attorney even if they can't afford one. And it's really that decision that has led to the creation of public defender systems across the country, and then private attorneys being appointed to represent those charged with crimes. I view that as one of the most important freedoms in the entire Bill of Rights.
As a young law student, I worked in a public defender's office, and it's just so clear. People who walk in the door are accused of a crime have no idea what their rights are or what they can do next or how to fight for their innocence. And public defenders are noble people. I tell you, a lot of thankless work, and they're still very much up against the system. But their job is not to free criminals. Their job is to ensure a fair trial for anyone accused of a crime, otherwise can't afford local counsel. Of course, Americans don't only end up in court because of criminal matters. The Seventh Amendment kicks in for a whole slew of other judicial business. This is the Seventh Amendment and suits at common law. You have to explain the $20 to me. And it essentially, there's more of the amendment that continues there. But David, why don't you give us an overview of the amendment and why it's still so important in America?
Yeah, the Seventh Amendment deals with trial by jury in civil cases primarily, but that is so important, that the right to trial by jury, as it says in many state constitutions, is inviolate. It's so important that our disputes are decided by our peers. I'm not sure there is a better way to give people the right to have high civic duty than to be able to serve on a jury and to understand how our legal system works. That's an incredible freedom. In criminal cases, it's an incredible freedom. It's also a freedom. It's also an incredible right in civil cases. Largely, this amendment is covered by statute or by state constitutions in different jurisdictions. But I think it's primarily important because it shows that the founding fathers realized that the importance of the right to jury trials.
Absolutely. Let's move to the Eighth Amendment. This and the two that follow are somewhat lesser known, and yet critically important in this case, especially in terms of keeping people from being jailed prior to being committed.
Absolutely. There's three freedoms in the Eighth Amendment: no excessive bail, no excessive fines, and no cruel and unusual punishment. Another reason why I'm so grateful for the revival of the book by you and the Free Speech Center is that it wasn't until 2019 in Thames v. Indiana that the U.S. Supreme Court formally incorporated the excessive fines clause of the Eighth Amendment. Most Eighth Amendment jurisprudence, however, focuses on that last freedom: what exactly is cruel and unusual punishment? And a lot of that focuses on the death penalty. Is the death penalty cruel and unusual punishment? And does it violate what the U.S. Supreme Court referred to in Trop v. Dulles in the 1950s? Does it violate our evolving standards of decency that mark the progress of a decent and maturing society? In 1972, in Furman versus Georgia, the U.S. Supreme Court, by a single vote, essentially ruled that the death penalty was cruel and unusual punishment. And so for 4.5 years, we did not have an official state execution in the United States of America. After Furman v. Georgia, legislators went back to the drawing board and crafted statutes, death penalty laws that provided for so-called aggravating factors and mitigating factors. And in 1976, in Gregg versus Georgia, the U.S. Supreme Court upheld those statutes. And so we've had the death penalty since 1976. However, fewer states now have the death penalty. While it's not per se unconstitutional, the U.S. Supreme Court in a series of rulings has said, for example, you may not execute the criminally insane. They did that in Ford v. Wainwright in 1987. They said that you may not execute those who are intellectually disabled. They did that in the Atkins decision in 2002. In 2005, in Roper versus Simmons, the U.S. Supreme Court said it violates the Eighth Amendment to execute those who commit murder when they are a juvenile, when they're under the age of 18. Now, a lot of the death penalty litigation involves over whether the particular process of lethal injection and the use of particular drugs causes and inflicts unnecessary and wanton pain on individuals. And I think that's like abortion, the death penalty, capital punishment is just one of those contentious issues that we're going to continue to debate for a long, long time.
Absolutely. And again, it's one of those that shows up at headlines almost daily. But the excessive bail issue, of course, is, bail is supposed to be intended to have people come back and appear for trial. But if you ask somebody who has limited means for too much money to be bailed out, then they end up actually serving a sentence for a crime they may never be convicted of. And that's critically important that the Supreme Court's incorporated that. Now we're moving into obscure territory, David. This is Amendment 9 in the Bill of Rights. Enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What in the world does that mean, David?
Well, there was a concern that if you list certain rights in the Bill of Rights, that these are the only rights that we have. And in fact, that was a debate on whether we should have the Bill of Rights at all, right? Because some members in the Federalist Party argued that the Bill of Rights itself was unnecessary because the Constitution itself was a Bill of Rights, right? Where it says no ex post facto laws, no bills of attainder, no religious tests for public office. But the reality is there's concern that listing these rights, if something wasn't listed, then there are no more rights. And so the Ninth Amendment says just because a right is not listed or enumerated does not mean necessarily that it doesn't exist. And you already identified when the Ninth Amendment came into vogue. It came into vogue in Griswold versus Connecticut in 1965, when Justice William O. Douglas invalidated that Connecticut law that prohibited the sale of contraceptives even to married persons. And the Ninth Amendment was mentioned a bit by Douglas, mentioned a lot by Justice Arthur Goldberg in his concurring opinion. That was somewhat controversial at the time because the Ninth Amendment has also often been referred to as a constitutional curiosity, and scholars are still exploring exactly what the Ninth Amendment means. And I think creative constitutional thinkers are thinking about what other rights out there could the Ninth Amendment be interpreted to protect, and that's a fascinating question.
And then there's one more arguable constitutional curiosity in Amendment 10. It tells us the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Translation?
Basically that we have a division of authority in this country. We have the federal government, and then we have state governments. The enduring constitutional term, or what I refer to my students as the appropriate legal lingo, is federalism. How do we allocate or divide power between the federal government and the state governments? The 10th Amendment ensures that states are active and viable participants in our constitutional experiment, and that there are times where the federal government may not commandeer state officials to enforce federal law, that states have a degree of sovereignty. It's sometimes referred to as state sovereignty, and how we divide authority between the federal government and the state governments is a hot-button political issue, and has been so for a very long time, and probably will be to come.
Thank you for marching through those 10 so eloquently. There's one hitch in the history of applying the Bill of Rights to citizens across America. It took a long time, a very long time, for those principles to be applied to the states, and that has to do, obviously, with the 10th Amendment as well, in terms of which governmental entities are going to be restricted by the Bill of Rights. I want to take a moment here and mention that if any of you have any questions for Professor Hudson, please put those in the comments section, and I will ask Emily on our team to read those to us in just a moment. It's important now, though, to look at this one more amendment, and that's the 14th Amendment to the U.S. Constitution. And this is the Equal Protection Clause, and it has been interpreted as meaning that each and every American should similarly benefit from the freedoms of the United States. And over time, the Supreme Court has incorporated the principles contained in the Bill of Rights to states. Not universal, but pretty darn close. I'm sure David knows what is not yet incorporated. But fundamentally, it applies those guarantees, those protections against the federal government are now protections against state government. Earth-shaking, this addition to the Constitution, wasn't it, David?
Absolutely. When James Madison made his Great Rights of Mankind speech to Congress back on June 8, 1789, he had what he referred to as his most valuable amendment. And that amendment said something to the effect that no state shall violate trial by jury, equal rights of conscience, or freedom of the press. James Madison realized that a lot of the infringements on individual liberty would come from state and local governments. But that amendment didn't pass Congress. And so in 1833, in the case Barron versus Baltimore, Chief Justice John Marshall looked at a case in which there was somebody alleging a Fifth Amendment violation. Problem was the Bill of Rights applies to the federal government, not the states. It took the 14th Amendment, which was ratified in 1868, in a series of U.S. Supreme Court decisions, mostly in the 20th century, with the exception of the Chicago-Burlington case in 1897. But the vast majority of them were in the 20th century, and it's through the Due Process Clause of the 14th Amendment, where it essentially says no state can violate life, liberty, or property without due process of law. So, for example, in 1925, in Gitlow versus New York, the U.S. Supreme Court reasoned that freedom of speech is part of that liberty, that these individual freedoms are so vital and so important that they're part of the liberty. So that's why the 14th Amendment has sometimes been viewed as a second Bill of Rights. It was a radical change. That's why the Congress that enacted the 13th, 14th, and 15th Amendments, they were referred to as the radical Republicans of the 39th Congress. They breathed the spirit of equality into the Constitution. They essentially took language from the Declaration of Independence and breathed that life into the United States Constitution, and they provided this important vehicle by which these freedoms limit not just the federal government, but state and local government officials as well.
It's striking how unprotected we were as Americans from what we now would view as unconstitutional actions by the states. It wasn't until this process of incorporation and that the Bill of Rights really became the potent weapons they are in protecting the civil rights of all Americans. Also, it's probably apparent from the context, very much tied to Reconstruction and the effort to make sure that freed slaves were treated as full citizens of the United States. David, you did an admirable job of marching through that, and I'm always impressed by your ability never to consult a note and always come up with every date and case. And that expertise is reflected in this new book, The Bill of Rights, the first 10 amendments, the 10 amendments to the U.S. Constitution. Emily, do we have anyone sharing a question?
Yeah, I'll start with a couple. The first one is asking, balancing personal liberty and social responsibility can be hard. I know we leave the judicial wrangling up to the courts, but is there an approach that we as Bill of Rights educators can take to better cultivate this balance in our students?
I think a concept that is very important, and it's something that permeated the feelings of the founding fathers, was the notion of the common good. And I think when we teach civic education, particularly back in the late 18th century, when we had the ratification of the Constitution later this week in 1787, right? And then the ratification of the Bill of Rights 4 years later, there was always this notion of what is the common good. And so there's always a difficulty in balancing what is the common good, but also allowing individual freedom and the ability to have an exemption from some of these general principles. And so I think when teaching about freedoms found in the Bill of Rights, we're not just talking about individual liberty, but we also need to talk about the common good.
Response. Another question, please.
Why do you think the Ninth Amendment is not used more frequently?
I think because it's fairly vague, right? It doesn't say what the rights are. And initially, it really wasn't until about 1937, 1938 that the United States Supreme Court really started caring more about individual freedoms. It actually arose from a footnote in a 1938 case, famous footnote 4, where Justice Harlan Fiske Stone said that there should be special scrutiny applied to laws that impact fundamental freedoms or negatively impact discrete and insular minorities. The court, through a lot of its history, was more concerned about protecting property rights. And I think that's part of the reason why Ninth Amendment jurisprudence really didn't take off. But we also have to realize that First Amendment jurisprudence really didn't take off until 1919. And Second Amendment jurisprudence has really took off in earnest in the early part of the 21st century, right? The Heller case wasn't until 2008. So I predict that the Ninth Amendment will be used with increasing frequency in the coming century. And it'll be exciting, as long as we're alive, it'll be exciting to see how that plays out.
All right, moving on, a question on the Eighth Amendment. Senator Cory Booker has frequently discussed ending cash bail. Do you think this will ever come to be? Can civil rights statutes be used to amend how we do bail in the U.S.?
I think there's a push for that, certainly in certain jurisdictions. I don't know if that would ever become nationwide. I think that, federalism is a bit messy, right? Certain jurisdictions do one thing and other jurisdictions do something different. Sometimes, in the pandemic, we've noticed that certain states have response A, response B, response C, response D, right? It's sometimes very difficult to have one uniform approach. So I don't know if that will, I certainly think that's the trend and that's the movement. And there's a recognition of what Ken so beautifully said earlier about somebody languishing in jail for a crime that is later determined they didn't commit simply because they don't have the money. That's a great question, and we'll just have to wait and see.
All right, we have one more. Do you think the original concerns of protecting property rights have made it difficult to protect or reauthorize personal rights? For example, the Voting Rights Act.
Obviously, property rights are still important. It's reflected in the just compensation clause, and in reaction to the Kelo case, there were all sorts of amendments to state constitutions that provided greater protection for property rights. I think that with regard to the Voting Rights Act of 1965, which was one of the seminal achievements, along with the Civil Rights Act of 1964 and the Fair Housing Act of 1968, I mean, that was really part of the Great Society of President Lyndon Baines Johnson. I think that in part, there is a concern about, it comes down to power and political power and which political party is in control. I don't necessarily think those two are connected that much.
Thank you for that. And this is one last good one to end on as we are coming up on time. Do you think the Bill of Rights is sufficient for our country 200 years later? And is it good or is it bad that it seems unchangeable?
I think it's wonderful. I think that the freedoms found in the Bill of Rights are important. It depends on how the United States Supreme Court interprets those freedoms. Right. Back in 1803, in a case called Marbury versus Madison, Chief Justice John Marshall declared the power of judicial review, the power of the courts to review whether acts of the legislative and executive branches are constitutional. And I said it's emphatically the province and duty of the judicial department to declare what the law is. So when we have a U.S. Supreme Court that's very protective of individual rights, that's very different from a U.S. Supreme Court that's not nearly as protective of individual rights. I do think the Ninth Amendment is important. If it comes to pass that there is this important constitutional right that needs protecting, then the Ninth Amendment does have that language that said just because it's not listed doesn't mean it's not there, that it's retained by the people. I think it's not the inadequacy of the Bill of Rights. I do think occasionally the U.S. Supreme Court makes a major misstep and does not interpret the Bill of Rights properly. I mean, every one of us has decisions or has certain U.S. Supreme Court decisions that we don't like. I, for example, don't like Garcetti versus Ceballos in 2006, where the U.S. Supreme Court unnecessarily curtailed the free speech rights of public employees. About 30 million people in America. That's something I've written on quite frequently for the Free Speech Center and the First Amendment Center before that. The Supreme Court decided Dred Scott v. Sanford in 1857 and Plessy v. Ferguson in 1896. These are bad decisions. But the Supreme Court also decided Brown versus Board of Education in May of 1954, right? They decided Times v. Sullivan. Now, Times v. Sullivan has been attacked by two sitting justices on the United States Supreme Court, Justice Clarence Thomas and Justice Neil Gorsuch, who have offered various criticisms of the ruling. So it's just the thing that I appreciate this, and I just feel eternally grateful, frankly, to Ken Paulson and the late, great John Sigenthaler for giving me the opportunity to devote much of my adult life to writing about First Amendment freedoms. That's what gave me the opportunity to develop a greater appreciation of constitutional freedoms. And I truly am grateful for that. I don't think I was adequately grateful when I was in my 20s and was very immature. But I've told Ken in later years that, I've matured a bit, and I'm very grateful for that opportunity.
Well, we're grateful for your expertise, David. As we close here, I just want to mention also regarding changing the Constitution, we do not want any changes of the Constitution in this polarized environment, because inevitably any changes are designed to curtail these freedoms. If you look at the history of our country, the only time we've attempted to take freedoms away was prohibition through a constitutional amendment. And you all know how well that worked out. You can drink to its demise a bit later in the day, perhaps. But the Constitution and the Bill of Rights have consistently been used to expand liberties. We've given the vote to 18-year-olds. We've given the vote to women and African Americans, and it has been a vehicle for expanding liberty in America. And in this environment, I don't think that would turn out that well. Let me close here by thanking all of you for attending this. Thank you, David, for your thoughtful reflections on this critically important document, the Bill of Rights. This book is available to anyone who has an interest in receiving it. It is a quick read. It is a paperback book that you can probably finish in 2 hours. It is written thoughtfully and conversationally. So if you're an educator, if you're a teacher in high school, this book would be a great assignment, maybe an extra credit assignment for your class. If you teach at a grade school level or middle school level, we would invite you to do exactly what we've done today. Just walk through the Bill of Rights and make sure your students have a sense of what each of those 10 liberties mean. The 8th, 9th, and 10th may not come in immediate use for them, but having them understand that there's a list of things that each and every American is guaranteed under our system of government, that will be so valuable to instill. And it wouldn't hurt also to tell them that we have a Bill of Rights because the American people demanded it. They would not ratify the U.S. Constitution, our most sacred document, until there were guarantees that a set of lists, the Bill of Rights, would also be adopted in 1791. So the entire system of U.S. government, our entire culture as a liberty-loving people, it all emanates from the Bill of Rights, the U.S. Constitution, and our own personal favorite, the First Amendment. Please spread the word. If you know educators, teachers, or others interested, let them know. All they have to do is send us an email to Free Speech Center, one word, at mtsu.edu and tell us who they are, what grade they teach, where they are. We'd love to know. These are absolutely free, and you'll receive either a digital copy or a print copy. So thank you for helping us spread understanding and awareness of these key freedoms. And David, thank you for your work on the front line.
Thank you so much.
It's been a pleasure having you.